Introduction. State liability under EU law allows individuals to claim compensation when they suffer loss because a member state has breached EU law. This principle was developed by the Court of Justice of the European Union to ensure the effectiveness and full enforcement of EU law, particularly where other remedies, such as direct effect, are unavailable. Legal basis and conditions. The doctrine of state liability was first established in Francovicz, Italy, and later refined in Brasserie du Pêcheur and Factor Tam III. For a claim to succeed, three cumulative conditions must be met. First, the EU rule breached must be intended to confer rights on individuals. Second, the breach must be sufficiently serious. Third, there must be a direct causal link between the breach and the damage suffered. Situations giving rise to state liability. A classic example is the failure to transpose a directive within the prescribed time limit. In Francovicz, Italy failed to implement a directive designed to protect employees' wage claims when their employer became insolvent. Because individuals could not rely on the directive through direct effect, the court held that the state was liable to compensate them. This represents the clearest case of state liability, as the breach was both obvious and serious. State liability may also arise from incorrect or defective implementation of EU law. In Brasserie du Pêcheur of Germany, national legislation conflicted with EU free movement rules. The court confirmed that even legislative acts of national parliaments can trigger state liability. Another important category involves breaches of settled CJEU case law. In Kübler-Vui, Austria, the court held that even courts of last instance may give rise to state liability, provided the breach of EU law is sufficiently serious. Finally, liability may result from administrative or judicial actions that clearly and manifestly violate EU law, especially where the error is inexcusable. Defenses available to a member state. Despite the wide scope of state liability, member states are not automatically liable in every case. A key defense is that the breach was not sufficiently serious. This is particularly relevant where the member state enjoyed wide discretion in implementing EU law. The court will consider factors such as the clarity of the rule, the margin of discretion, and whether the infringement was intentional or excusable. A second defense arises where EU law was unclear or still developing at the time of the alleged breach. If there was no clear guidance from the Court of Justice, the breach may be regarded as excusable. Third, a member state may argue that there is no direct causal link between the breach and the damage suffered. If the loss resulted from independent or intervening factors, state liability will not arise. Finally, where a member state reasonably relied on existing national or EU case law, this may reduce the likelihood that the breach will be classified as sufficiently serious. Conclusion. State liability is a vital enforcement mechanism within the EU legal system. It ensures compensation for individuals harmed by serious breaches of EU law, including failures to transpose directives, incorrect implementation, and disregard of settled case law. At the same time, the availability of defenses ensures a balance between effective protection of individual rights and respect for member state autonomy. Through this balance, state liability strengthens the authority and effectiveness of EU law without imposing excessive or unfair burdens on member states.